Hey crew, it's Pitt, and I am back with some more freedom. Today we're going to continue our energetic investment into our union by reading aloud from the Federalist Papers. We will be doing Federalist Paper number 64, 65, and 66, dealing with the powers of the Senate. From the New York Packet, Friday, March 7th of 1788, authored by John Jay, to the people of the state of New York. It is a just and not a new observation that enemies to particular persons and opponents to particular measures seldom confine their censures to such things and only in either as are worthy of blame. Unless, on this principle, it is difficult to explain the motives of their conduct, who condemn the proposed Constitution in the aggregate, and treat with severity some of the most unexceptionable articles in it. The second section gives power to the President by and with the advice and consent of the Senate to make treaties, provided two-thirds of the senators present concur. The power of making treaties is an important one, especially as it relates to war, peace, and commerce, and it should not be delegated but in such a mode and with such precautions as will afford the highest security that it will be exercised by men the best qualified for the purpose, and in the manner most conducive to the public good. The convention appears to have been attentive to both these points. They have directed the president to be chosen by a select body of electors, to be deputed by the people for that express purpose, and they have committed the appointment of senators to the state legislatures. This mode has, in such cases, vastly the advantage of elections by the people in their collective capacity, where the activity of party zeal, taking the advantage of the supineness, the ignorance, and the hopes and fears of the unwary and interested, often places men in offices by votes of a small proportion of the electors. As the select assemblies for choosing the president, as well as the state legislatures who appoint the senators, will in general be composed of the most enlightened and respectable citizens, there is reason to presume that their attention and their votes will be directed to those men only who have become the most distinguished by their abilities and virtue, and in whom the people perceive just grounds for confidence. The Constitution manifests very particular attention to this object, by excluding men under 35 from the first office and those under 30 from the second. It confines the electors to men of whom the people have had time to form a judgment, and with respect to whom they will not be liable to be deceived by those brilliant appearances of genius and patriotism, which, like transient meteors, sometimes mislead as well as dazzle. If the observation be well founded that wise kings will always be served by able ministers, it is fair to argue that an assembly of select electors possess, in a greater degree than kings, the means of extensive and accurate information relative to men and characters. So will their appointments bear at least equal marks of discretion and discernment. The inference which naturally results from these considerations is this, that the President and senators so chosen will always be of the number of those who best understand our national interest, whether considered in relation to the several states or to foreign nations, who are best able to promote those interests, and whose reputation for integrity inspires and merits confidence. With such men the power of making treaties may be safely lodged. Although the absolute necessity of system in the conduct of any business is universally known and acknowledged, yet the high importance of it in national affairs has not yet become sufficiently impressed on the public mind. They wish to commit the power under consideration to a popular assembly composed of members constantly coming and going in quick succession, seem not to recollect that such a body may necessarily be inadequate to the attainment of those great objects which require to be steadily contemplated in all their relations and circumstances, and which can only be approached and achieved by measures which not only talents but also exact information, and often much time, are necessary to concert and to execute. It is wise, therefore, in the convention to provide not only that the power of making treaties should be committed to able and honest men, but also that they should continue in place a sufficient time to become perfectly acquainted with our national concerns and to form and introduce a system for the management of them. The duration prescribed is such as will give them an opportunity of greatly extending their political information and of rendering their accumulating experience more and more beneficial to their country. Nor has the convention discovered less prudence in providing for the frequent elections of senators in such a way as to obviate the inconvenience of periodically transferring those great affairs entirely to new men. For by leaving a considerable residue of the old ones in place, uniformity and order, as well as a constant succession of official information, will be preserved. There are a few who will not admit that the affairs of trade and navigation should be regulated by a system cautiously formed and steadily pursued, and that both our treaties and our laws should correspond with and be made to promote it. It is of much consequence that this correspondence and conformity be carefully maintained, and they who assent to the truth of this position will see and confess that it is well provided for by making concurrence of the Senate necessary both to treaties and to laws. It seldom happens in the negotiation of treaties, of whatever nature, that perfect secrecy and immediate despatch are sometimes requisite. These are cases where the most useful intelligence may be obtained if the person possessing it can be relieved from apprehensions of discovery. Those apprehensions will operate on those persons whether they are actuated by mercenary or friendly motives, and there doubtless are many of both descriptions. Who would rely on the secrecy of the President, but who would not confide in that of the Senate, and still less on that of a large popular assembly? The convention having done well, therefore, in so disposing of the power of making treaties, although the President must, in forming them, act by the advice and consent of the Senate, yet he will be able to manage the business of intelligence in such a manner as prudence may suggest. They who have turned their attention to the affairs of men must have perceived that there are tides in them, tides very irregular in their duration, strength, and direction, and seldom found to run twice exactly in the same manner or measure. To discern and to profit by these tides in national affairs is the business of those who preside over them. And they who have had much experience on this head inform us that there frequently are occasions when days, nay, even when hours are precious. The loss of a battle, the death of a prince, the removal of a minister, and other circumstances intervening to change the present posture and aspect of affairs, may turn the most favorable tide into a course opposite to our wishes. As in the field, so in the cabinet, there are moments to be seized as they pass, and they who preside in either should be left in capacity to improve them. So often and so essentially have we heretofore suffered from the want of secrecy and dispatch that the Constitution would have been inexcusably defective if no attention had been paid to those objects. Those matters which in negotiations usually require the most secrecy and the most dispatch are those preparatory and auxiliary measures which are not otherwise important in a national view, then as they tend to facilitate the attainment of the objects of the negotiation. For these, the President will find no difficulty to provide, and should any circumstance occur which requires the advice and consent of the Senate, he may at any time convene them. Thus we see that the Constitution provides that our negotiations for treaties shall have every advantage which can be derived from talent, information, integrity, and deliberate investigations on the one hand, and from secrecy and dispatch on the other. But to this plan, as to most others that have ever appeared, objections are contrived and urged. Some are displeased with it, not on account of any errors or defects in it, but because, as the treaties, when made, are to have the force of laws, they should be made only by men invested with legislative authority. These gentlemen seem not to consider that the judgment of our courts and the commissions constitutionally given by our governor are as valid and as binding on all persons whom they concern as the laws passed by our legislature. All constitutional acts of power, whether in the executive or in the judicial department, have as much legal validity and obligation as if they proceeded from the legislature, and therefore whatever name can be given to the power of making treaties, or however obligatory they may be when made, certain it is that the people may, with much propriety, commit the power to a distinct body from the legislature, the executive, or the judicial. It surely does not follow that because they have given the power of making laws to the legislature, that therefore they should likewise give them the power to do every other act of sovereignty by which citizens are to be bound and affected. Others, though content that treaties should be made in the mode proposed, are averse to their being the supreme law of the land. They insist and profess to believe that treaties, like acts of assembly, should be repealable at pleasure. This idea seems to be new and peculiar to this country, but new errors as well as new truths often appear. These gentlemen would do well to reflect that a treaty is only another name for a bargain, and that it would be impossible to find a nation who would make any bargain with us which should be binding on them absolutely, but on us only so long and as far as we may think proper to be bound by it. They who make the laws may without doubt amend or repeal them, and it will not be disputed that they who make treaties may alter or cancel them. But still, let us not forget that treaties are made, not by only one of the contracting parties, but by both, and consequently that as the consent of both was essential to their formation at first, so must it ever afterwards be to alter or cancel them. The proposed Constitution, therefore, has not in the least extended the obligation of treaties. They are just as binding and just as far beyond the reach of legislative acts now as they will be at any future period or under any form of government. However useful jealousy may be in republics, yet when, like bile in the natural, it abounds too much in the body politic, the eyes of both become very liable to be deceived by the delusive appearances which that malady casts on surrounding objects. From this cause, probably, proceeds the fears and apprehensions of some, that the President and Senate may make treaties without an equal eye to the interest of all the states. Others suspect that 2/3 will oppress the remaining third, and ask whether those gentlemen are made sufficiently responsible for their conduct, whether, if they act corruptly, they can be punished, and, if they make disadvantageous treaties, how are we to get rid of those treaties? As all the states are equally represented in the Senate, and by men the most able and the most willing to promote the interests of their constituents, they will all have an equal degree of influence in that body, especially while they continue to be careful in appointing proper persons, and to insist on their punctual attendance. In proportion as the United States assume a national form and a national character, so will the good of the whole be more and more an object of attention, and the government must be a weak one, indeed, if it should forget that the good of the whole can only be promoted by advancing the good of each of the parts or members which compose the whole. It will not be in the power of the President and Senate to make any treaties by which they and their families and estates will not be equally bound and affected with the rest of the community, and, having no private interest distinct from that of the nation, they will be under no temptations to neglect the latter. As to corruption, this case is not supposable. He must either have been very unfortunate in his intercourse with the world, or possess a heart very susceptible to such impressions. Who can think it probable that the President and 2/3 of the Senate will ever be capable of such unworthy conduct? The idea is too gross and too invidious to be entertained. But, in such a case, if it should ever happen, the treaty so obtained from us would, like all other fraudulent contracts, be null and void by the law of nations. With respect to their responsibility, it is difficult to conceive how it could be increased. Every consideration that can influence the human mind, such as honor, oaths, reputations, conscience, the love of country, and family affections and attachments, affords security for their fidelity. In short, as the Constitution has taken the utmost care that they shall be men of talents and integrity, we have reason to be persuaded that the treaties they make will be as advantageous as, all circumstances considered, could ever be made. And so far as the fear of punishment and disgrace can operate, that motive to good behavior is simply afforded by the article on the subject of impeachments. And so ends Federalist Paper number 64. Basically, this was dismissing the doubts, right? People were concerned that we didn't need to have a Senate. We had already brought in the legislature, and people were already concerned that the legislature would have too much power. But the high turnover in the legislature ensures that that doesn't happen. The problem with that is that they don't have time to learn a lot of things, right? If it's a 2 year stint, they don't have time to learn the things that are necessary to deal with treaties and lasting things. Now, presumably, 2/3 of the 6 year terms, these people serve for 6 years, and 2/3 of them are required to approve of the treaty. So that is a safeguard against the things that people are talking about. And it's like, there's no real reason to even address this, but we are going to address it. And so we did. That's basically what we did here. We just talked about the fact that the executive and the Senate are going to act as checks against each other, because you're not going to be able to convince 2/3 of the Senate and the president to be corrupt enough to accept a bad treaty. And that's the gist of that. So now we're going to move on to Federalist Paper number 65. The powers of the Senate continued from the New York packet, Friday, March the 7th of 1788, authored by Alexander Hamilton, to the people of the state of New York. The remaining powers which the plan of the convention allots to the Senate in a distinct capacity are comprised in their participation. Let me put my glasses on, I'll read better. In a distinct capacity are comprised in their participation with the executive in the appointment to offices, and in their judicial character as a court for the trial of impeachments. As in the business of appointments, the executive will be the principal agent. The provisions leading to it will most properly be discussed in the examination of that department. We will, therefore, conclude this head with a view of the judicial character of the Senate. A well-constituted court for the trial of impeachments is an object not more to be desired than difficult to be obtained in a government wholly elective. The subjects of its jurisdiction are those offenses which proceed from the misconduct of public men, or, in other words, from the abuse or violation of some public trust. They are of a nature which may with peculiar propriety be denominated political, as they relate chiefly to injuries done immediately to the society itself. The prosecution of them for this reason will seldom fail to agitate the passions of the whole community, and to divide it into parties more or less friendly or inimical to the accused. In many cases it will connect itself with the pre-existing factions, and will enlist all their animosities, partialities, influence, and interest on one side or on the other, and in such cases there will always be the greatest danger to that decision will be regulated more by the comparative strength of the parties than by the real demonstrations of innocence or guilt. The delicacy and magnitude of a trust which so deeply concerns the political reputation and existence of every man engaged in the administration of public affairs speaks for itself. The difficulty of placing it rightly in a government resting entirely on the basis of periodical elections will as readily be perceived when it is considered that the most conspicuous characters in it will, from that circumstance, be too often the leaders or the tools of the most cunning or the most numerous faction, and on this account can hardly be expected to possess the requisite neutrality those whose conduct may be the subject of scrutiny. The convention, it appears, thought the Senate the most fit depository of this important trust. Those who can best discern the intrinsic difficulty of the thing will be least hasty in condemning that opinion, and will be most inclined to allow due weight to the arguments which may be supposed to have produced it. What, it may be asked, is the true spirit of the institution itself? Is it not designed as a method of national inquest into the conduct of public men? If this is to be the design of it, who can so properly be the inquisitors for the nation as the representatives of the nation themselves? Is it not disputed that the power of originating the inquiry, or, in other words, of preferring the impeachment, ought to be lodged in the hands of one branch of the legislative body. Will not the reasons which indicate the propriety of this arrangement strongly plead for an admission of the other branch of that body to share of the inquiry? The model from which the idea of this institution has been borrowed, pointed out that course to the convention. In Great Britain, it is the province of the House of Commons to prefer the impeachment, and the House of Lords to decide upon it. Several of the state constitutions have followed this example. As well as the latter, as the former, seems to have regarded the practice of impeachments as a bridle in the hands of the legislative body upon the executive servants of the government, is this not the true light in which it ought to be regarded? Where else than in the Senate could have been found a tribunal sufficiently dignified or sufficiently independent? What other body would be likely to feel confidence enough in its own situation to preserve, unawed and uninfluenced, the necessary impartiality between an individual accused and the representatives of the people, his accusers? Could the Supreme Court have been relied upon as not answering this description? It is much to be doubted whether the members of that tribunal would, at all times, be endowed with so eminent a portion of fortitude as would be called for in the execution of so difficult a task. And it is still more to be doubted whether they would possess the degree of credit and authority which might, on certain occasions, be indispensable towards reconciling the people to a decision that should happen to clash with an accusation brought by their immediate representatives. A deficiency in the first would be fatal to the accused, and the last dangerous to the public tranquillity. The hazard in both these respects could only be avoided, if at all, by rendering that tribunal more numerous than would consist with a reasonable attention to economy. The necessity of a numerous court for the trial of impeachments is equally distracted by the nature of the proceeding. This can never be tied down by such strict rules, either in the delineation of the offense by the prosecutors, or in the construction of it by the judges, as in common cases serve to limit the discretion of courts in favor of personal security. There will be no jury to stand between the judges who are to pronounce the sentence of the law and the party who is to receive or to suffer it. The awful discretion which a court of impeachments must necessarily have, to doom to honor or to infamy the most confidential and the most distinguished characters of the community, forbids the commitment of the trust to a small number of persons. These considerations alone seem sufficient to authorize a conclusion that the Supreme Court would have been an improper substitute for the Senate as a court of impeachments. There remains a further consideration which will not a little strengthen this conclusion. It is this: the punishment which may have been the consequence of conviction upon impeachment is not to terminate the chastisement of the offender. After having been sentenced to a perpetual ostracism from the esteem and confidence and honors and emoluments of this country, he will still be liable to prosecution and punishment in the ordinary course of law. Would it be proper that the persons who had disposed of his fame and his most valuable rights as a citizen in one trial should, in another trial for the same offense, be also the disposers of his life and his fortune? Would there not be the greatest reason to apprehend that error in the first sentence would be the parent of error in the second sentence? That the strong bias of one decision would be apt to overrule the influence of any new lights which might be brought to vary the complexion of another decision? Those who know anything of human nature will not hesitate to answer these questions in the affirmative, and will be at no loss to perceive that by making the same persons judges in both cases, those who might happen to be objects of the persecution would, in great measure, be deprived of the double security intended them by a double trial. The loss of life and estate would often be virtually included in a sentence which, in its terms, imported nothing more than dismission from a present and a disqualification for a future office. It may be said that the intervention of a jury in the second instance would obviate the danger, but Juries are frequently influenced by the opinions of judges. They are sometimes induced to find special verdicts which refer the main question to the decision of the court. Who would be willing to stake his life and his estate upon the verdict of a jury acting under the auspices of judges who had predetermined his guilt? Well, let's let that sit for a second. Would it have been an improvement of the plan to have united the Supreme Court with the Senate in the formation of the Court of Impeachments? This union would certainly have been attended with several advantages, but they would not have been overbalanced by the signal disadvantage already stated, arising from the agency of the same judges and the double prosecution to which the offender would be liable. To a certain extent, the benefits of that union will be obtained from making the Chief Justice of the Supreme Court the President of the Court of Impeachments, as is proposed to be done in the plan of the Convention, while the inconveniences of an entire incorporation of the former into the latter will be substantially avoided. This was perhaps the prudent mean. I forbear to remark upon the additional pretext for clamor against the judiciary which considerable an augmentation of its authority would have afforded. Would it have been desirable to have composed the court for the trial of impeachments of persons wholly distinct from the other departments of the government? There are weighty arguments, as well against as in favor of such a plan. To some minds it will not appear a trivial objection that it could tend to increase the complexity of the political machine, and add a new spring to the government, the utility of which would at best be questionable. But an objection which will not be thought by any unworthy of attention is this: a court formed upon such a plan would either be attended with a heavy expense, or might, in practice, be subject to a variety of casualties and inconveniences. It must either consist of permanent officers, stationary at the seat of government, and of course entitled to fixed and regular stipends, or of certain officers of the state government to be called upon whenever an impeachment was actually depending. It will not be easy to imagine any third mode, materially different, which could rationally be proposed. As for the court, for reasons already given, ought to be numerous, the first scheme will be reprobated by every man who can compare the extent of the public wants with the means of supplying them. The second will be espoused with caution by those who will seriously consider the difficulty of collecting men dispersed over the whole Union, the injury to the innocent from the procrastinated determination of the charges which might be brought against them, the advantage to the guilty from the opportunities which delay would afford to intrigue and corruption, and in some cases the detriment to the state from the prolonged inaction of men whose firm and faithful execution of their duty might have exposed them to the persecution of an intemperate or designing majority in the House of Representatives. Though this latter supposition may seem harsh, and might not be likely often to be verified, yet it ought not to be forgotten that the demon of faction will, at certain seasons, extend his scepter over all numerous bodies of men. But though one or the other of the substitutes which have been examined, or some other that might not be devised, should be thought preferable to the plan in this respect reported by the convention, it will not follow that the Constitution ought for this reason to be rejected. If mankind were to resolve to agree in no institution of government until every part of it had been adjusted to the most exact standard of perfection, society would soon become a general scene of anarchy, and the world a desert. Where is the standard of perfection to be found? Who will undertake to unite the discordant opinions of a whole community in the same judgment of it, and to prevail upon one conceited projector to renounce his infallible criterion for the fallible criterion of his more conceited neighbor? To answer the purpose of the adversaries of the Constitution, they ought to prove, not merely that particular provisions of it are not the best which might have been imagined, but the plan, upon the whole, is bad and pernicious. And so ends Federalist Paper number 65, and here we have a whole lot of very relevant examples. The power of the Senate is to make the judgment on whether impeachment should proceed. The House of Representatives can bring impeachment against the executive, but then the Senate has to say, yes, we agree, by a 2/3 majority. We have recently been saved from an injudicious impeachment by factions, by these very powers prescribed right here. It is very fortunate for our country that indeed extra powers were invested in the Senate to prevent a faction deciding to randomly and for no cause to impeach a sitting president. That happened a few years back. If you're unaware of that, you're probably leaning a little bit to the left. And that's not even to call out political factionism, but it's a real thing. It is really affecting us in real time. We are even seeing it in the judiciary. There are currently several cases that are falling apart because they are brought merely for faction purposes. It is merely to keep a leading candidate from being able to campaign. That is the cause, and if you don't believe that, you probably lean a little bit to the left. None of these charges have any foundation. None of them are going to stick. I'm going to say that now, like I said it a year ago whenever they started it. None of them are going to stick because none of them have a foundation. This is, again, something that they were trying to prevent, because if the power would have been invested in the judiciary in the state of New York, we would have a severe problem, right? If it was in the Supreme Court, there might have even been a problem. The fact that it was separated the way that it is indeed shown to be effective. Nixon was impeached. He was never convicted. There was, who else was it? There was someone else who was impeached and not convicted. And then, Clinton. And then you had what they did with Trump several times. We are probably, for no reason whatsoever, going to be facing another one soon. When I say no reason whatsoever, that means that the end result will not be productive, right? All the crimes were committed prior to being president. They actually happened. The charges should actually be brought. There should be actual persecution. But we're 6 months from an election. We're less than a year from a new president being in place. Good Lord willing, and the creeks don't rise. And so we should be able to allow this process to take place without putting into place the first woman president who was completely incompetent for the position. Separation of powers is a good thing. All of our current circumstances point to that with screaming clarity. The Federalist Paper number 66. Objections to the power of the Senate to set as a court for impeachments further considered. From the New York Packet, Tuesday, March the 11th of 1788, authored by Alexander Hamilton to the people of the state of New York. A review of the principal objections that have appeared against the proposed court for the trial of impeachments will not improbably eradicate the remains of any unfavorable impressions which may still exist in regard to this matter. The first of these objections is that the provision in question confounds legislative and judiciary authorities in the same body, in violation of that important and well-established maxim which requires a separation between the different departments of power. The true meaning of this maxim has been discussed and ascertained in another place, and has been shown to be entirely compatible with a partial intermixture of those departments for special purposes, preserving them in the main and distinct and unconnected. This partial intermixture is even, in some cases, not only proper but necessary to the mutual defense of the several members of the government against each other. An absolute or qualified negative in the executive upon the acts of the legislative body is admitted by the ablest adepts in the political science to be an indispensable barrier against the encroachments of the latter upon the former. And it may, perhaps, with no less reason be contended, that the powers relating to the impeachments are, as before intimated, an essential check on the hands of that body upon the encroachments of the executive. The division of them between the two branches of the legislature, assigning to one the right of accusing, to the other the right of judging, avoids the inconvenience of making the same persons both accusers and judges, and guards against the danger of persecution from the prevalency of a factious spirit in either of those branches. As the concurrence of 2/3 of the Senate will be requisite to a condemnation, the security to innocence from this additional circumstance will be as complete as itself can desire. It is curious to observe with what vehemence this part of the plan is assailed, on the principle here taken notice of by men who profess to admire, without exception, the Constitution of the state, while that Constitution makes the Senate, together with the Chancellor and judges of the Supreme Court, not only a court of impeachments, but the highest judiciary in the state, in all causes, civil and criminal. The proportion, in point of numbers, of the Chancellor and judges to the senators is so inconsiderable that the judiciary authority of New York, in the last resort, may, with truth, be said to reside in its Senate. If the plan of the convention be, in this respect, chargeable with a departure from the celebrated maxim which has been so often mentioned and seems to be so little understood, how much more culpable must it be the Constitution of New York? A second objection to the Senate as a court of impeachments is that it contributes to an undue accumulation of power in that body, tending to give to the government a countenance too aristocratic. The Senate, it is observed, is to have a concurrent authority with the executive in the formation of treaties and in the appointment to offices. If, say the objectors, to these prerogatives is added that of deciding in all cases of impeachment, it will give a decided predominancy to senatorial influence. To an objection so little precise in itself, it is not easy to find a very precise answer. Where is the measure or criterion to which we can appeal for determining what will give the Senate too much, too little, or barely the proper degree of influence? Will it not be more safe, as well as more simple, to dismiss such vague and uncertain calculations, to examine each power by itself, and to decide on general principles where it may be deposited with most advantage and least inconvenience? If we take this course, it will lead to a more intelligible, if not a more certain result. The disposition of the power of making treaties which has obtained in the plan of the convention will, then, if I mistake not, appear to be fully justified by the considerations stated in a former number, and by others which will occur under the next head of our inquiries. The expediency of the junction of the Senate with the executive and the power to appointing offices will, I trust, be placed in a light not less satisfactory, in the disquisitions under the same head, and I flatter myself the observations in my last paper must have gone no inconsiderable way towards proving that it was not easy, if practicable, to find a more fit receptacle for the power of determining impeachments than that which has been chosen. If this be truly the case, then hypothetical dread of the too great weight of the Senate ought to be discarded from our reasonings. But this hypothesis, such as it is, has already been refuted in the remarks applied to the duration in office prescribed for the senators. It was by them shown, as well on the credit of historical examples as from the reason of the thing, that the most popular branch of every government, partaking of the republican genius, by being generally the favorite of the people, will be as generally a full match, if not an overmatch, for every other member of the government. But, independent of this most active and operative principle, to secure the equilibrium of the national houses of representatives, The plan of the convention has provided in its favor several important counterpoises to the additional authorities to be conferred upon the Senate. The exclusive privilege of originating money bills will belong to the House of Representatives. The same House will possess the sole right of instituting impeachments. Is this not a complete counterbalance to that of determining them? The same House will be the umpire in all elections of the President, which do not unite the suffrages of a majority of the whole number of electors, a case which cannot be doubted will sometimes, if not frequently, happen. This constant possibility of the thing must be a fruitful source of influence to that body. The more it is contemplated, the more important will appear this ultimate, though contingent, power of deciding the competitions of the most illustrious citizens of the Union for the first office in it. It would not, perhaps, be rash to predict that, as a means of influence, it will be found to outweigh all the peculiar attributes of the Senate. A third objection to the Senate as a court of impeachments is drawn from the agency they are to have in the appointments to office. It is imagined that they would be too indulgent judges of the conduct of men in whose official creation they had participated. The principle of this objection would condemn a practice which is to be seen in all the state governments, if not in all the governments with which we are acquainted. I mean that of rendering those who hold offices during pleasure dependent on the pleasure of those who would appoint them. With equal plausibility might it be alleged in this case that the favoritism of the latter would always be an asylum for the misbehavior of the former. But that practice, in contradiction to this principle, proceeds upon the presumption that the responsibility of those who appoint for the fitness and competency of the persons on whom they bestow their choice, and the interest they will have in the respectable and prosperous administration of affairs, will inspire a sufficient disposition to dismiss from a share in it all such who, by their conduct, shall have proved themselves unworthy of the confidence reposed in them. Though facts may not always correspond with this presumption, yet, if it be, in the main, just, it must destroy the supposition that the Senate, who will merely sanction the choice of the executive, should feel a bias towards the objects of that choice, strong enough to blind them to the evidences of guilt so extraordinary as to have induced the representatives of the nation to become its accusers. If any further arguments were necessary to evince the improbability of such bias, it might be found in the nature of the agency of the Senate in the business of appointments. It will be the office of the President to nominate, and with the advice and consent of the Senate to appoint. There will, of course, be no exertion of choice on the part of the Senate. They may defeat one choice of the executive and oblige him to make another, but they cannot themselves choose. They can only ratify or reject the choice of the President. They might even entertain a preference to some other person at the very moment they were assenting to the one proposed, because there might not be no positive ground of opposition to him, and they could not be sure, if they withheld their assent, that the subsequent nomination would fall upon their own favorite, or upon any other person in their estimation more meritorious than the one rejected. Thus, it could hardly happen that the majority of the Senate would feel any other complacency towards the object of appointment than such as the appearances of merit might inspire, and the proofs of the want to destroy it. A fourth objection to the Senate in the capacity of the Court of Impeachments is derived from its union with the executive in the power of making treaties. This, it has been said, would constitute the senators and their own judges, in every case of a corrupt and perfidious execution of that trust, after having combined with the executive in betraying the interest of the nation in a ruinous treaty. What prospect, it is asked, would there be of their being made to suffer the punishment they would deserve, when they were themselves to decide upon the accusations brought against them for the treachery of which they have been guilty? This objection has been circulated with more earnestness and with a greater show of reason than any other which has appeared against this part of the plan, and yet I am deceived if it does not rest upon an erroneous foundation. The security essentially intended by the Constitution against corruption and treachery in the formation of treaties is to be sought for in the numbers and characters of those who are to make them, the joint agency of the Chief Magistrate of the Union and of two-thirds of the member of a body selected by the collective wisdom of the legislatures of the several states, is designed to be the pledge for the fidelity of the national councils in this particular. The convention might, with propriety, have mediated the punishment of the executive for a deviation from the instructions of the Senate, or a want of integrity in the conduct of the negotiations committed to him. They might also have had in view the punishment of a few leading individuals in the Senate, who should have prostituted their influence in that body as the mercenary instruments of foreign corruption. But they could not, with more or equal propriety, have contemplated the impeachment and punishment of two-thirds of the Senate, consenting to an improper treaty, than of a majority of that or of any other branch of the national legislature consenting to a pernicious or unconstitutional law, a principle which, I believe, has never been admitted into any government. How, in fact, could a majority in the House of Representatives impeach themselves? Not better. It is evident that two-thirds of the Senate might try themselves. And yet, what reason is there that a majority of the House of Representatives, sacrificing the interest of the society by an unjust and tyrannical act of legislation, should escape with impunity, more than two-thirds of the Senate sacrificing the same interest in an injurious treaty with a foreign power? The truth is that in all such cases it is essential to the freedom and to the necessary independence of the deliberations of the body that the members of it should be exempt from punishment for acts done in a collective capacity. And the security to the society must depend on the care which is taken to confide the trust in proper hands, to make it their interest to execute it with fidelity, and to make it as difficult as possible for them to combine in any interest opposite to that of the public good. So far as might concern the misbehavior of the executive in perverting the instructions or contravening the views of the Senate, we need not be apprehensive of the want of a disposition in that body to punish the abuse of their confidence or to vindicate their own authority. We may, thus far, count upon their pride, if not upon their virtue, and so far even as might concern the corruption of leading members, by whose arts and influence the majority may have been inveigled into measures odious to the community. If the proofs of that corruption should be satisfactory, the usual propensity of human nature will warrant us in concluding that there would be commonly no defect of inclination in the body to divert the public resentment from themselves by a ready sacrifice of the authors of their mismanagement and grace. And so ends Federalist Paper number 66. And this is where we're going to wrap it up. This was, again, emphasizing the need to keep the powers separated, and I absolutely agree. As I just talked about in the last paper, we have example of the safeguards they were trying to introduce here actually being safeguards that were used in the future. So I don't have an awful lot to add to this, right? We're investing the energy of reading aloud the founding documents and the reasoning behind the founding documents, because I believe in energetic investment. I believe that we speak reality into existence, and that the more people who listen to this and the more people who speak these things out loud, the more likely they are to actually become reality. I think that we have the best system in the world. Is it perfectly executed? Of course not. It is executed by people. But it is still, by far, the best in the world. If you want to debate that in the comments, feel free. I might even make a video out of it, because I really do believe that we have more opportunity here than anywhere else. We have more chance here to be free and to live as we want to than anywhere else on the planet. We have ceded way too many of our powers away because we are not informed. We don't honor intelligence. We don't back up people with knowledge. We go with the parrots, with the talking heads, and I want to change that, so I am endeavoring to change that. Hopefully, I brought a little bit of enlightenment and not too much to confusion. I don't have a whole lot to add other than to give contemporary examples, right? These documents speak for themselves. I'm not trying to change anything, but you should always go back and read. I leave the link down below so that you can go back and see for yourself and make sure that I am being truthful and honest about what I am reading. Never take it for granted, even if it's here. Like, I give it to you right here next to me, and you watch me scroll through. Still don't take my word on it. Go back and read it for yourself. It is highly important that you understand these things, especially you if you are here this far along, because you are the ones that are going to make the difference. It's not going to be the people who click on and click away. It's going to be the people who watch and try to understand. We make the difference, not them. They're complacent. They don't change anything. To the crew, thanks for hanging out. I appreciate every single minute that you are here with me, and I am praying for you every single day. Until next time, I love you. God loves you. You are perfect, whole, and complete just the way that you are. And this has been Pitt State. Peace.